We're live.
Good afternoon. This is the House Judiciary Committee. We're having our first of two voting sessions today. There will now be a second voting session after the end of the session on the floor today, which will begin at 3 o'clock. I'm not sure when that session will end, but we will have a voting session 30 minutes after the floor session this afternoon. There are 5 bills on this voting list. And what I'm going to do is we're going to start with discussion related to Senate Bill 53, which is the Senate version of the juvenile interrogation bill. It's the intent of the chair to conform House Bill 269 to the Senate bill. So to that end, Delegate Bartlett, who has been working on this legislation, if you could tell us, please, what Senate Bill 53 does now, please.
Sure. Thank you, Mr. Chair. So Senate Bill 53, of course, first adds some co-sponsors, and then also changes the title of the bill and strikes out juvenile and includes child. So it's the Child Interrogation Protection Act. Senate Bill 53 also just the amendments, Mr. Chair. Okay, all right. And so on page 5 of the bill, Senate Bill 53 strikes out some information regarding imminent threat to the life of the individual, reasonable delay, things of that sort, and instead states that it essentially creates exigent circumstances, and states that the law enforcement may, if he or she reasonably believes that the information sought is necessary to protect against a threat to public safety. We put that in there mostly because it's unpredictable, unfortunately, these days, what types of threat may occur, and the threat may very well be, could very well be against an officer or anyone else. So we just kept it broad and said a threat against public safety. We did the same thing under G1 and G2 and just struck out the life of the individual language. On page 7, actually on page, on page 6, I'm sorry, on page 6, we also kind of tweaked the rebuttable presumption that is available that prosecutors can use. And that rebuttable presumption, we state that there is a rebuttable presumption that a statement made by the child during the custodial interrogation is inadmissible. And then we start to outline some of the situations in which it is inadmissible. And one thing that we had in there was it was inadmissible against the child if law enforcement willfully failed to comply with the requirements. Instead, we changed it to against that child because there was some confusion there, to make it clear that it was against that child, and that the information or the protection of this bill or this section only applies to proceedings against the child that to which the questions or the interrogation was directed, and that it would it may not be construed to render a statement by that child, the one who was subject to the interrogation, inadmissible in a proceeding against another individual. So we included that language. And then last, we also included language to explain threat to public safety. As I said, we used it in broad terms, but we referenced it back to Miranda versus to the exception in Miranda versus Arizona. One last thing that I overlooked, and that is we also amended No, actually, we didn't. We kept it. Okay. And those are all the amendments, and I moved the amendment, although we're not ready to do that, right, Mr. Chair?
I don't think we're quite ready to do that. I
Okay.
mean, first of all, the amendments, just to be clear, would be to Delegate Bartlett's House bill, which we still have in our possession, which would then conform the House bill to the Senate bill that was sent over. And then we would attempt to send both of them back. Let me do this. Are there questions for Delegate Bartlett as to what the bill does now? And so we can at least have this part of the conversation and go from there. So we're going to start with Delegate Crutchfield.
Thank you, Mr. Chair, and thank you so much, Delegate Bartlett, for working so diligently on this bill. I just wanted to make sure I understand what Amendment 3 really now does for the bill. Can you just explain that? Because there are a couple of parts to Amendment 3. There's a Section 2 and a 3, and I just want to make sure I understand those.
Okay, let me make sure we're looking at the same thing. So hold on one second.
This appears to be related to what the state has to demonstrate to overcome the presumption.
That is correct, Mr. Chair. That is
Okay.
correct.
I think it's a clear and convincing standard that's used there.
Correct. And then also how, again, rendering a statement by that child inadmissible in a proceeding against another.
Right. So in that section, people were concerned that one, we wanted to have a situation where, let's say, a police officer just made a mistake. It wasn't willful. It was just a mistake. And we wanted to make clear that it had to be a willful omission in order to not include the statement. But we also wanted to be clear that it does not necessarily take out the statement that was made against another individual who was being charged in another case. So it would only be, because the whole purpose of the bill is to afford protections around self-incrimination. It's not necessarily meant to necessarily knock out any statements that a witness may make who's involved or who might have seen another individual commit a crime.
Thank you so much.
Mm-hmm.
Delegate Anderson, then Davis.
Yeah, thank you, Mr. Chair. And yeah, great work from the committee on the subcommittee. My concern is with the changing of the language. I think you said from exigent circumstances to consideration for public safety. Could you explain that one again to me?
Well, sure. Actually, what we changed was imminent threat, because the question is, what is imminent? That became the argument in our work session. What is imminent? What is immediate? Things of that sort. So what we decided instead was a threat to a threat to public safety, and it was more encompassing, and it was some language that the prosecutors could live with. So it's not as exigent circumstances, even though I just fuddled that word, but it's not exigent circumstances. It's the imminent threat that we changed.
Okay, my concern with that is that the idea of a threat to public safety is a fairly vague and huge term, almost a catch-all. It is currently used extensively by judges when considering whether or not to release a person on bond or on his recognizance, or to retain a person in custody. And the judge has to determine whether or not that person is a threat to public safety. And I have seen a wide, huge range of things where judges consider someone a threat to public safety. Obviously, if a person has been convicted a couple of times of the use of a handgun, and it's the same charge now, yes, certainly that's a threat to public safety. But there's been situations where is a single domestic violence incident qualified the person as a threat to public safety, when in fact you might have argued that he was a threat to the partner or to the spouse. And I just think a threat to public safety is yeah, I understand wanting to try to, get the prosecutors involved or on board, but the whole point of this bill is to ensure that our children aren't subject to unusual interrogation or intimidating interrogation from police officers. And I think after the fact, once they've gotten what they've gotten, or what they saw it, then they can make the argument, well, yeah, we thought it was a threat to public safety. And here's why, because somebody said that there might have been a gun in the house or something, or whatever the case may be. I just think that there's got to be a more tangible way to figure out how we can ensure that the only time that this phrase or this clause or this ability is used when there's actual harm, imminent harm, exigent circumstances, or to me, were all better than just a vague saying, well, there's a threat to public safety. He was a threat to public safety.
Right. And, and I understand your point, Delegate Anderson. In fact, this is why we went round and round and round on this. We spent a lot of time on this language. And that's also why we put in the language that the threat to public safety that we are referencing must be that which complies with Miranda. So we used the threat to public safety. So we made a reference back to Miranda and said that this is the type of situation that we're talking about, that it's just not, anything, it's not in any circumstance necessarily, but it puts the requirement back on the state to prove that there was in fact a threat to public safety and that it does comply with what the Supreme Court has already deemed as a particular threat to public safety. It can't just be, it's not meant to be just a general. It has to be in compliance with Miranda as to why the exception to the rule should apply.
I don't understand how you conflate the two. The Miranda, I mean, an individual who receives a Miranda warning, an adult, it's absolute. The warning, Miranda is read to you. You have a right to remain silent. You have absolute right to an attorney. You have absolute right to remain silent. If you can't afford an attorney, one will be appointed for you. There's no circumstances that allow a police officer, no exigent or threat to public safety circumstances that allow a police officer to get around the Miranda rights of adults.
Well, I respectfully disagree that there is a public safety exception in Miranda that says that that in certain circumstances, if if an officer doesn't give Miranda warning and ask where the gun is, and there actually is a threat to public safety, then that statement could possibly be allowed by stating that the threat to public safety was that the officer believed this individual to have a gun. You do this all the time. You practice this all the time. Right. We worked with public defenders who practice this type of law all the time, as well as state's attorneys, and who are in this field. It is a subject of debate, Delegate Anderson. It is. It is not decided 100% clear, but it was intended. The bill was amended in this fashion so that it would be reviewed on a case by case basis, or a fact pattern by fact pattern basis, and not so much we didn't want to completely tie law enforcement's hands that with the language that we had before, and that was that it had to be an imminent threat to the life of the individual, and a reasonable delay would, somehow taint, harm the life of the threatened individual. There were so many circumstances where that didn't apply. So unfortunately, this was the closest language that we got to that would allow the bill to go forward.
Okay, well, again, I appreciate the deliberations that went on with this, but when you talk about tying law enforcement's hands, again, the situation that we're looking at is an adult police officer with a gun and a badge, probably interviewing a child who's could be 10, 12, 13 years old, either in the car of the police officer or in the station of the police officer or in some room where the child feels maybe intimidated. And I'm saying that the whole point of this bill is to ensure the rights of these children to be free from that kind of intimidation. And I don't think that giving them, I don't think that tying the hands of law enforcement is what the bill contemplated. I think the bill contemplated tying the hands of law enforcement or trying to reduce the practices where there's this unequal situation between children and police.
I respect that. I do respect that. That is the goal of the bill. That is definitely the goal of the bill.
But I don't think we achieve that goal by leaving this phrase in there, that this catchphrase, public safety. It's such a large catchphrase. I think that we've watered the bill down to the point where it really doesn't make any difference, because the argument that they'll use won't be until after all the interrogation is done. The police will feel free to do the interrogation feeling as if they're justified because of this catchphrase. Oh, well, in the interest of public safety, we didn't respect the child's rights to remain silent. We kind of forced the child to talk, and we got what we needed. And then later in court, they can say, then it's adjudicated whether or not it was done correctly. But in the meantime, the child has been subjected to this interrogation based upon, I think, a kind of a lax interpretation of the law that, well, we did it in the name of public safety.
Yeah,
that's all I'll say.
I got you. We're on the same page with it. We're on the same page.
Okay.
Delegate Davis, then the vice chair. Delegate Davis.
Thank you, Mr. Chair, and thank you, Delegate Bartlett, for your hard work on this. I've got a couple questions, and one is, in this bill, custodial interrogation of a 5-year-old and a 15-year-old, there's no distinction made.
No, there's no distinction.
Okay. And there was talk earlier about a Miranda warning that would be drafted that would be more understandable to a minor. Is there any reference to that?
Yes, that language is still in the bill. And it is actually on page 3, if you have the bill, in section E, where the Court of Appeals may adopt rules concerning age-appropriate language to be used to advise children who are taken into custody.
So it's not in the bill, it's going to be drafted.
No, it's in the, right, the language, yes, you're right. You're right, Delegate Davis. The language itself is not in the bill.
And I think Delegate Anderson maybe asked one of my questions. And so I want your opinion as to whether the rights that we're going to afford children are at least at the base of the rights that we afford adults at this time.
Yes, it is at the same level of the rights we afford adults, plus a little bit extra. And that's intentional because we are talking about children. And the extra is that they, the interrogation, except for the circumstances we were just talking about, the interrogation cannot begin unless the juvenile has had the opportunity to talk to an attorney. And that's very important. It's very, very important. It's important for a child to understand what they are facing, because the problem is that there have been so many false confessions. I mean, the numbers of false confession, it's actually quite sad. And we have situations in Maryland where individuals went in as juveniles who falsely confessed and ended up serving time for a crime that they didn't commit, but they didn't understand. And that happens too often, where children do not understand the law, and then they waive their rights. These rights cannot be waived without the individual talking to an attorney first, not their parent. Okay, it's the attorney that they must talk to before their rights could be waived.
Thank you.
Thank you.
Vice Chair, please.
Thank you, Mr. Chair. I have to say, first, offhand, I share Delegate Anderson's concerns about what this kind of language does to a bill like this. However, I am also aware this bill has been attempted for quite some time and was one of the less consensus items from some of these debates. And so I'm just flipping through the record here and seeing that in JPR, our friends across the street, these changes to the bill netted them a single Republican in committee, our friend Senator Huff, in an 8-3 vote in JPR. All the other Republicans voted against. And on the floor, it was just Senator Huff, it looks like, joined on the yes vote. And it was a 31-15 vote. So I guess this seems to me plausible as veto material. So I'm sort of familiar with the presentment timing. And so I just have to ask, what do the advocates who wanted this bill think of where we are at with what the Senate did to the bill at this stage in the game?
Well, they were in the room with me. We were there with OPD in the room. I've had weekly meetings with the advocates and to discuss the bill and all the changes. They are not, they want the bill out. Would they like it to be even stronger than it is? Yes, they would like for it to be even stronger. But you know what happens when there is a level of, some level of debate. Sometimes you get it stronger, sometimes you get it kind of like in the middle. And that's kind of where we are now. We're kind of in the middle. And, here's the thing.
Well, to be clear, sometimes people ask us to kill, they would rather, have another go at it and kill the bill. And sometimes they would like to proceed. And I guess that's the question. And Mr. Chair, I have a point of information also. Do we even have time to do a second round of revision between the House and Senate if we disagree at this point and still make a presentment deadline?
I mean, I think you would need to have everyone. I mean, I'll just say generally, we're at 2 weeks right now. I mean, there's going to be a fairly busy week this week, but
But what happens with the timeline if we kick it back, deleting some of this language, and
I don't know the answer to that question because I haven't talked to anybody in the Senate with regard to that. I mean, I don't want to be facetious, but
Yeah,
I think
okay.
we're at a point where, we're 2 weeks to go.
Okay.
Yeah. Well, here's the thing. They're definitely not talking withdraw the bill at all. They're talking go forward. We're having almost nothing short of almost prayer meetings at this point. Yes, I said that, Mr. Chair.
Now we're going to prayer meetings. All right. Let's do this. I think we're going to stop the discussion. I'm a little hesitant to say this next part, but it is something I wanted to say at the beginning. I am not directing it towards this bill, whether there should be amendments or not. I am just going to say that if anyone has amendments to this or any of the other bills, that we will need them. Let's just say, I'm going to guess that our session tonight will end at about 6 o'clock. I need them by 6 o'clock or by the end of the legislative or the floor session of the House tonight for this or any of the other bills that we're going to discuss this afternoon. So I'll just set that for 6 o'clock. If the floor ends earlier than 6 o'clock, then we will plan on voting at 6:30. And so I'll set that time right now, that my intention is to have a voting session then at 6:30. So any amendments would need to be done by 6. So if you're thinking about amendments, now's the time. With
Okay.
that,
Mr. Chair, can I just say one quick,
sure.
very quick thing? Perhaps I can talk to Delegate Anderson. Perhaps you and I could talk afterwards, because I do want to, we do have some other information here that I think might help us, and that is the lawful custodial interrogation of a child. So we still have that language in there, but I'll talk to you afterwards, and I'd like your expertise to see if the way we have it, perhaps there's more there than what we went over, because I was trying to just focus on the amendment.
You talking to me?
Yes,
Okay.
Delegate Anderson.
Okay.
Yeah. Okay. Thank you. Thank you, Mr. Chair.
Thank you. We'll stop talking now about the child interrogation bill, and we're going to go very briefly, I think, to Senate Bill 29, which is the marriage, setting age requirements for marriage. I spoke with the now chair of Ways and Means, the sponsor of the House bill here. She would like to conform the Senate bill to what we passed out of the House. So I will give everybody a heads up that that is what I would suspect the motion will be on Senate Bill 29 when we come back after session tonight. So just give you the heads up with that. Senate Bill 279 will need an amendment, and this is Holly's bill. And Holly, could you tell us what Senate Bill 279 does? This is, I think, let me take a swing at it. This is the legislation that allows for settlements that come from AG cases in the areas related to evictions and housing, that money would go into the Access to Counsel Fund, right?
Yes, that's correct.
Okay, well, first time today. But there is a need for an amendment. Can you describe what that amendment would be, please?
Sure. The amendment's conforming, and it just conforms to House Bill 571, the cross file. We put this amendment on our bill, and it just clarifies that the fund excludes money received. Well, right now it says received by the aggrieved party, and per the AG, they wanted us to say restitution to make sure that those damages, that it was clear. And so that's all the amendment does.
So it effectively puts it in the same posture that it left the House, correct?
Exactly.
All right.
And the Senate is going to pass, I actually just got a note, they're going to pass House Bill 571 as we sent it. So both bills will match with this amendment.
I see. Okay. All right. So are there questions as to what is being proposed for Senate Bill 279? All right, seeing none. So Senate Bill 662, I believe it's a cross file from a Delegate Ben Barnes bill, but it has to do with direct funding for access to counsel. And again, Holly, could you just review what that legislation does? And I don't believe it needs an amendment, correct?
Nope, we're going to pass it with the Senate amendments. And this bill is a mandated appropriation in the budget. And it requires in fiscal 2024 only that the comptroller distributes $14 million from the state's unclaimed property fund to the Access to Counsel and Evictions Fund. And the bill further just mandates that the governor has to include in the annual budget that appropriation in 2024.
Okay. Are there questions related to the access to counsel or the funding bill, Senate Bill 662? All right. I was hopeful we would get further, but again, we have several people who are still coming to Annapolis. I don't want people to vote and drive. And so to that end, we're going to go ahead and I think we will stop right here. We plan on coming back after tonight's voting session. Again, amendments due by the end of the voting session or 6 p.m. or by the end of the floor session or 6 p.m., whichever is later. intend to have the voting session at about 6:30. We'll see how long the floor goes tonight. And for any changes, anybody watching can watch the Maryland General Assembly website. So